Thank you. Welcome, everybody, to House General and Finance.
Nope.
No. House General and Housing. Yes, my mind is mushed after yesterday. Today is Thursday, March 27th, all day. And we're gonna have a half hour, 15-minute tutorial from one of our legislative counsel, Sophie Statney. And then at 9:15, we're going to take up H-173, which is an act relating to granting public employees the right to strike, and take some testimony. All right. Sophie.
Good morning, Sophie Zadatny for the Office of Legislative Counsel. And I'm going to hopefully on my screen. Okay, all right. So I was asked to provide an overview on the right to strike under Vermont's labor relations laws. And just a quick refresher, got to get off the screen here, let me just read it. We have 7 collective bargaining laws in Vermont. We kind of did an overview earlier in the session. The State Labor Relations Act covers private employers, so not public sector. And again, it only covers those employers, private employees not covered by the Labor Relations Act. So it's a very rarely used statute here in Vermont. And then just jumping down to the bottom, number 6 and 7, those involve sort of limited subject bargaining, primarily over compensation rates with the state. Employees covered by those 2 statutes are also not considered state employees. So we're really talking about 2, 3, 4, and 5. So under the Labor Relations for Teachers and Administrators Act, there is a right to strike, as there is under the Municipal Employee Relations Act. And right now there's a prohibition on striking under SELRA, the State Employees Labor Relations Act, and under JELRA, the Judiciary Employees Labor Relations Act. So just to orient everybody.
Wait a minute, I want to go back over that.
Okay.
So under SELRA,
Yes.
again, there's no right to strike?
So right to strike is prohibited under SELRA and JELRA. So number 2 and number 5.
Okay. And are the others silent on it, or?
No, we're going to get into
Okay.
labor relations for teachers and administrators, the Municipal Employee Relations Act. We'll cover them all. I just wanted to give you a quick heads up. Okay. So again, just at the federal level, the National Labor Relations Act, again, does not cover public sector employees. The National Labor Relations Act does recognize the right to strike as fundamental. There are limitations and qualifications placed on that right. And so while the right to strike in the private sector is governed by federal law, the right to strike in the public sector exists only to the extent it's granted by state law. So there is no federal law granting public sector employees the right to strike. So there are a dozen states, including Vermont, that give some public sector workers the right to strike. So again, our teachers and municipal employees in Vermont. And there are only 9 states that allow teachers to strike, Vermont being one of them, and none others in New England. And just by way of a little bit of history, in 2015, the House of Representatives narrowly rejected a bill that would have prevented teachers from striking and school boards from imposing contracts unilaterally. And there was another bill in 2018 that failed to advance, that came out of the Senate. So just a little bit of background on that. So just general information on strike. So the lawfulness of strikes depends on the object and purpose of the strike, the timing of the strike, the conduct of the strikers. And there are 2 classes of lawful strikes, and we'll talk a little bit more about those as we go through this, but unfair labor practice strikers and economic strikers. And I just included the last point there because we had a question last time around nursing. So under the National Labor Relations Act, there is a prohibition on striking or picketing a healthcare institution without at least 10 days notice. So I know we had that question last time. Sorry, my voice is going. So I just included that in here.
RNs only?
It's just generally under the healthcare is covered as a private employer. They're covered by the National Labor Relations Act. So But yeah, you can't, again, it's that notice for public, safety.
So the National Labor Relations Act covers only private.
Right,
So consequently, public employees is a creature of state law.
right, exactly. All right. So again, just to reiterate, so under Vermont state law, there's no right to strike by workers and no contract imposition by management under 4 of the 7 contracts that we have. Again, the 3 and 4 really don't involve, state employees. They're sort of quirky ones. They're involving state reimbursement. But for all 4 of these, the dispute resolution procedure is once there's impasse, the parties have reached, they can't resolve it on their own, then they would go to mediation, fact finding, and then selection of last best offer by the Vermont Labor Relations Board or the arbitrator. And I highlighted SELRA because SELRA is the act that is the subject of 173, the bill that you're looking at amending. This is the statutory definition of strike. It's under the Municipal Employee Relations Act, but it's the same definition that applies under the Teachers Act as well. So it's conduct by an employee or employee organizations or their agents that produces, induces, or encourages a work stoppage, slowdown, or withholding of services. Such conduct includes recognizing a picket line or other conduct that interferes with or impedes the orderly functions and services of a municipal employer. So just turning to the Municipal Employee Relations Act, and again, Vermont just has so many different variations under their labor relations law, so I just separated out the 2. So under the Municipal Employee Relations Act, the statutory dispute resolution process is mediation upon request by either party, fact finding upon request by either party, arbitration, the parties can voluntarily submit a dispute to binding arbitration, or a municipality by referendum can adopt binding arbitration. So municipalities, if it passes by a referendum, can have binding arbitration, which means then you're foregoing the ability to strike. So there is a limited right to strike that's permitted if arbitration is not invoked.
Is in terms of fact finding, when a fact finding report is complete, what is usually included in a fact finding report? Does it take sides? I mean, what does it do?
So fact finding, so under the Municipal Employee Relations Act, there's a single fact finder that's appointed by the Commissioner of Labor. So again, every statute has its own little differences. And then typically what happens with a fact finder is the parties put on evidence to support their particular position. The fact finder hears the evidence, the fact finder will issue a report. And sort of what the fact finder believes would be a reasonable resolution of the issues that are in dispute. The report is not binding on either party, but it's a way the parties can figure out, they may think, well, I've got a really strong argument on this, and the fact finder's not buying it. So it may cause them to think a bit harder about whether that's a position they want to hold to or whether they're willing to compromise on it.
So on the key positions, the fact finder reviews the evidence, and it's like a judicial opinion, in that they reach a conclusion of their own.
Right, and make recommendations, but again, non-binding, but can make
Right.
recommendations.
Is the fact finding report usually very long? It's like a large document.
It's going to depend. I mean, maybe you've only got one issue in dispute, maybe you've got 10 issues, so yeah. All right. So under the Municipal Employee Relations Act, striking is not permitted within 30 days after delivery of a fact finder's report. So that's really effectively a cooling off period. So it gives the parties an opportunity to read the fact finder's report, to consider, if the fact finder made some good points, maybe they need to reevaluate their position. It's also not permitted when the parties have voluntarily submitted a dispute to final and binding arbitration. So once the parties have agreed, we're going to go to arbitration, then there's no option to strike. There's obviously no option then for the municipality to also impose any contract terms. There's also no right to strike once the decision or award has been issued by the arbitrator. So it's binding arbitration. That's it. whatever the arbitrator decides, that's it. And then strikes under the Municipal Employee Relations Act, if are not permitted, if it will endanger the health, safety, or welfare of the public. And if there's the employer, the municipality has a concern about that, they can seek an injunction or other relief from the court. And interestingly, under the Municipal Employee Relations Act, I haven't had any experience with it, it just seems quirky to me, but the way arbitration works under this particular act is that each side picks a member of an arbitration panel, and then the two members that are picked then pick a third person that will be the chair of the arbitration panel. And that's how they do it. Often arbitrators are just a single person, but under this particular act, the 3-person panel. And if the two people that are picked by either side, if the parties can't agree, if they can't agree on a third person, then the Superior Court picks who will be the third person who will chair the arbitration panel. Sure.
So do they, being an odd number, they never come to an impasse? Like, do the
Right,
arbitrators
the goal-
themselves try to come out with a unanimous
Yes.
decision?
Well, yeah, but they need to come out with a binding decision because that's ultimately going to be the contract at that point.
So when under MELRA,
Mirror, yes.
MERA, if MERA, there's no labor in there. Okay, MERA, under MERA, there is a right to strike if you don't choose arbitration.
Right. So if the parties don't choose to go to arbitration and they've gone through the process, they've done mediation, fact finding, whatever, and they can't agree, there is a right to strike. And then there's also a right then for management to unilaterally impose conditions or impose the contract.
So the right to strike and imposition both only can occur after fact finding.
Yeah, I mean, the goal is to have the way the statutes generally are written is to push the parties to try to work this out on their own, because the goal is always to have the parties themselves figure out, what the contract's going to be, rather than having an external party do that. So these mechanisms are really designed to drive the parties together and to keep them talking and to keep them working on issues to try to get to a point where there's agreement. All right, so the Labor Relations for Teachers and Administrators Act. So again, there's a statutory dispute resolution process, there's mediation. And again, the parties can jointly agree to mediate or they can bypass that step. Fact finding upon request of either party. So in this case, there's a fact finding committee. So it's the other way around to the Municipal Employee Relations Act, which had just a single fact finder and a panel of 3 on arbitration. This time around, under the Teachers Act, it's a fact finding committee, same thing. Each side picks somebody. The 2 individuals that are picked, one from each side, then pick a third person who will be the chair. And if they can't agree, then they go to the American Arbitration Association to pick the third person. And again, this has a little bit more meat in it in terms of what happens at fact finding for the chair.
Yes, you have a question?
What do you mean by picking the third person?
So it's a 3-person panel. So each
Right.
side gets to pick a person to be on the panel, and then the 2 panelists then pick the third person. So it's a 3-person panel,
So the third person is the chair.
and the third person will serve as the chair.
Okay, and the chair can't break. If there's a tie, the chair doesn't break.
Yeah, no, the chair would, right? You
Oh,
could have a
okay.
2-1 determination. So the fact-finding committee, again, informal hearings, testimony, presentation of evidence. The committee can request information. And they also are issuing a non-binding written report where they're recommending a reasonable basis for settlement. And again, quite tight timelines. The goal is to have it within 30 days of appointment. And again, the report is made public if the issues in dispute aren't resolved within 10 days. So the goal is, you issue the report, again, the parties can reevaluate their situation, hopefully resolve it. If not, then the report is made public.
Is the MERA report made?
It's not specific in the statute on that. I mean, presumably it could be, but
So then if they don't make it, there's a right to strike.
so the Vermont Labor Relations Board has held that teachers cannot strike and a school board can't take unilateral action on matters in dispute until 30 days after receipt of the fact finder's report. So that's not in the statute, but that's the VLRB has held that. And again, so there's that cooling off period. And then unusually in the Labor Relations for Teachers and Administrators Act, there's this sentence under Section 2008. All decisions of the school board regarding matters in dispute shall, after compliance with this chapter, be final. So there is VLRB case law around that. So matters in dispute means the school board can't, they've got 3 issues that are in dispute. They can't then impose a contract on a 4th issue, has not been part of the dispute, part of the negotiations. The after full compliance with this chapter is to prevent school boards from doing what's called shadow bargaining and just sort of going through the motions just to get to a point where they can then impose a contract. So it's always going to be very closely scrutinized to make sure that the school board didn't do a hurry up negotiating to get to that point and impose a contract. So the after full compliance with this chapter, you have to have bargained in good faith to get there.
Is that the imposition of the contract, is that limited to 1 year?
Yes, yeah. So this is just some examples. An economic strike within 8 days of receipt of a fact finder's report was considered an unfair labor practice, because again, you haven't had that full cooling off period. There is language in the statute that a court can issue a restraining order or injunction if the continuation of the strike poses a clear and present danger to a sound program of school education. I was not able to find any cases either from the Supreme Court or from the Labor Relations Board actually elucidating what that means. So I can't give you any wisdom on that. And yeah, on the teachers' strike, the Vermont Labor Relations Board has held that if the board is unilaterally imposing the contract, it can only be prospective if it's an economic loss to the teachers or administrators. So if, for example, if they want to, increase the healthcare premium or not have a step increase that was already part of the original contract, they can't do that retroactively. They can only do it prospectively. And again, only for 1 year. They can't impose a contract for more than 1 year.
What happens after a year of an imposed contract?
You're back to the bargaining table to bargain over the next.
Can another contract be imposed if there's?
If you haven't, you could go through the whole process and start the whole cycle again.
Yes.
I mean, it's something would be a danger to a sound program, but could it be like they choose to strike a week before finals and graduation, and so a whole class of seniors would
To be determined.
not graduate? And okay,
Yeah, there haven't been any, I could not find anything that's elucidated that. So then under the Labor Relations for Teachers and Administrators Act, the limitations on the right to strike, again, not before 30 days have passed since the fact finder's report. Prohibited if it occurs after both parties have voluntarily agreed to submit the dispute to final and binding arbitration. And again, prohibited once an arbitrator has issued a decision, because again, that's then binding.
Is there any limitation in any of the right to strike situations to what they can strike on? I mean, if supposing they want to strike, I assume they can strike on the contract.
Right.
But what about, can they strike on, dissatisfaction with some working condition, which is not a subject of the contract?
So you would go through the process, right? So if there was an issue around a working condition, then you would look at the contract, you'd go through the process for that, right? Whether that's a grievance or if there's an unfair labor practice, you would look at that, and then you would go through the process before you would go to a strike. You wouldn't just strike immediately. If you did, then just going back to that earlier slide, depending on the timing and the behavior, right, that could then be considered an unlawful strike. The benefit for a lawful strike, that you can be reinstated, right? And particularly if it's for an unfair labor practice. So an economic strike is typically over wages, economic, but unfair
But a
labor
lawful
practice.
economic strike can be over a matter that is not part of a contract negotiation.
I mean, I guess I'm trying to figure out the scenario.
They're unhappy with, the DEI practices.
Well, I mean, typically you would have a conversation. I mean, again, the whole process, it's labor relations, the whole goal is the relationship. So you wouldn't just go out on strike, I would hope, you know.
But, well, you
Don't
would
like
make a,
that. You would go
if
through a whole
you
process.
made a demand that something happen and,
It's, yeah, it's going to be governed by the contract that the parties have, like what the
Right.
process is for dealing with issues. And again, if there's a belief that one side is engaged in an unfair labor practice, that may justify, you know, going out. I mean, there are some examples. There's not a lot of examples. There haven't been a lot of strikes. But for example, under the Municipal Employee Relations Act, there was a strike in a particular situation. This is back in the 80s. And the employer said, you know, fired everybody and then said, well, you can come back if you agree not to be a member of the union. And it's like, well, no, that's an unfair labor practice. You can't do that. You know, so, you know, there are things that are going to cross the line.
So there are clear definitions as to what an unfair labor practice is.
Yeah, there's definitions, there's in statute, there's also case law that you can look at. And again, there's not much in Vermont, as often happens the case in the legal world. We don't have a lot of case law. So again, courts will, and certainly the Vermont Labor Relations Board historically has looked at what's happened at the National Labor Relations Board. So if there isn't anything analogous here in Vermont, a lot of the early cases cite National Labor Relations Act cases. So although we're not, the public sector employees aren't covered by the National Labor Relations Act, there are a lot of principles, just basic labor relations principles that are established through federal law. So again, the parties under the Teacher and Administrators Act can agree to arbitration. Again, both sides need to agree. It needs to be in writing. Once they've agreed, it can't be revoked. They can agree to arbitrate anytime after impasse, so they don't have to go through mediation and fact-finding. Again, interestingly, under the Teachers Act is what we've talked about before is last best offer, where, again, to kind of drive the parties together right at the end. Under this act, the parties can decide on what the arbitrator's jurisdiction is. So they can agree that either the arbitrator will agree on a single package or will pick a last best offer from the entire package from one side or the other side, or they can agree that the arbitrator will decide on an issue by issue basis on each side's last best offer on a particular issue. And again, once they've agreed to go to arbitration, then the arbitrator's decision is going to be final. And again, and this is true the whole way through, but the parties share equally in the cost. The fee and the cost for the arbitrator.
but do they have to, whatever approach they take, do they have to use last best offer?
Yeah, it's still last best offer, but it could be either a whole package or it could be issue by issue.
Does the committee understand last best offer? Maybe you better explain last best
Yeah.
offer.
So last best offer is just, it's for each side to really take a long, hard look at what issues they dispute and what their position on those issues are. And so it's a mechanism whereby it kind of drives the parties closer together, because particularly if it's going to be a all or nothing, either your package gets picked or the other side's package gets picked. You want to make yours as appealing as possible to the decision maker, whether it's the board or an arbitrator. You want it to be as reasonable as possible. So it makes people compromise, you know.
Which is, for the committee, by the way, in California, this is called baseball. It's just the term for
I
this.
thought baseball was the game you played with. Sticks,
It is,
balls, but
but if you don't have last offer and you have an arbitrator, the fear, of course, of the parties is the arbitrator is gonna go to the middle. So that pushes parties to the more extreme. In other words, why not ask for the world if the arbitrator is gonna, to use the biblical term, cut the baby in half? But on the other hand, last best offer says the arbitrator is going to go one way or the other. And so that means the parties are pushed to try to be as reasonable as they can and still represent their interests.
and I would say that it certainly is being clear through Labor Relations Board decisions is, and these again are not the two we just talked about, the Municipal Employee Relations Act and the teachers. They're not going to the Labor Relations Board to get the final decision. But under for example, the State Employee Labor Relations Act, where you do go to the board or you go to an arbitrator, the board has been very clear. The goal is always to get the parties to figure this out, not the last thing they want to do is impose a contract. The goal is to get the parties to work it out.
Any final questions? We're running just a little behind. Any final questions from Sophie? Sophie, thank you so much. And
Welcome.
so we're going to proceed now with that introduction. We're going to proceed to hear H-173. And our first witness will be Sharon Scott, who's Chief Financial and Operating Officer of the Vermont State College System. So, Sophie, thank you for warming up the chair.
Yes. Not the first time we've tagged off.
It is not the first time we've tagged off.
I should disclose to the committee that I am one of the legislative trustees on the Vermont State College Board. So I think it's fair to say that I have somewhat conflicting fiduciary duties here, which I will just, in the Vermont style, learn to manage. And that in that context, I have worked with Sharon Scott. Sharon, take it away.
Well, thank you, Mr. Chair, and thank you to the committee for letting me come here today and speak. So for the record, my name is Sharon Scott. I'm the Chief Financial and Operating Officer of the Vermont State Colleges System. And it was really my pleasure last week to have the opportunity to talk to Heather Reedmer from AFT Vermont about their proposal to allow employees of the Vermont State Colleges and the University of Vermont the opportunity to be able to strike. The AFT represents 6 of the 7 bargaining units that are at the Vermont State Colleges. And in our conversation, it was really clear that we shared 3 things. And the first is that we care really deeply about the state of Vermont. Second, we both understand that the ability to be able to strike is the single most powerful tool that labor unions have in their toolbox. And third, we believe that labor should have tools that are equal to that of management, because we both agree that the best agreements are made between equals, and that that's incredibly important to us. Where we differ is that the Vermont State Colleges believes that the existing SELRA law is the best means of allowing us to be able to level that playing field between labor and management. It's, as Mrs. Dotnier explained, it's the overarching law that governs the ways in which the state of Vermont and its component units, like the Vermont State Colleges, work with our collective bargaining units. The law is designed to really serve in the best interest of the public by really requiring that at each and every step, the parties have to work together. We have to work together to reach a mutual agreement as much as possible. And that mutual agreements are the foundation truly of public sector labor law. Because the highest duty of care for services for Vermonters is that we have under SELRA, it really requires very careful and deliberate processes that are designed to truly minimize the disruption in public services while carefully balancing the powers between labor and management. The existing law right now explicitly prohibits employees at the Vermont State Colleges from being able to strike. And on the surface, this prohibition could be seen as contrary to that most powerful tool in the toolbox that labor has, which is the ability to be able to strike. However, under SELRA, there are tools that balance that. And through a combination of specific dispute resolution processes, we believe that SELRA offers that opportunity. The first is an arbitration process that is used for grievances that cannot be resolved by the parties on their own. And those grievances then go ultimately to the labor board for decision. The second is an impasse process for disagreements in contract negotiations that really require the support of an approved mediator, followed by fact-finding, followed by the ability to be able to submit that to the VLRB. And lastly, the unfair labor practice, which is a process that can be filed by an employee, the bargaining unit, or management in situations in which it is believed that there is an unfair labor practice that is occurring, whether that's by management or by labor. Each of these processes force us to have continued conversation. Neither party can dig in their heels and refuse to cooperate. And we really have to keep working together in order to be able to find a solution. And in the event that a solution cannot be reached, the final decision rests with the VLRB, the neutral body that was established under SELRA to hear such cases. It's definitely not a perfect solution. Obviously, no one wants to have to submit to the VLRB, but it's one that works for the benefit of Vermont and Vermonters, as labor and management at the table for public employment. Each party really knows that there's no nuclear option, such as a strike or a contract imposition or a lockout. So there's no way for management to unilaterally impose its will on its bargaining units. Instead, we have to keep working together to continue to provide the essential services that are needed for Vermont and Vermonters. As Ms. Sadotny noted, the Teachers Act and the Municipal Employees Relations Act do offer a limited ability to strike. In the case of the teachers, that is done through a complex process that does allow the school board to ultimately be able to impose a contract for 1 year on the parties and then go back to the table again. And it's a powerful tool that truly ends litigation. Balanced against that unilateral power is the teacher's ability to be able to strike after that contract has been imposed for a year. And in practice, these two powers are truly balanced, so that neither is issued until the collective bargaining process actually fails. Consistent with this balance, both the school board's right to impose and the teacher's right to strike does involve a cooling off period, as Ms. Zadotny noted. After a fact finder's report, and that strike is not allowed to be able to endanger the health, safety, or welfare of the public. And in the Municipal Relations Act, there's also a limited ability to be able to strike after the exhaustion of the law's mandated dispute processes. And we want to contrast this with the language that's in the proposed bill. As proposed, there are no parameters around this powerful action, none. And as Ms. Zadotny noted, the NLRB does not dictate the terms of striking beyond defining what a strike consists of. Therefore, we believe that this bill would allow our workers to be able to strike over working conditions, a grievance, contract negotiations that aren't going well, or even under conditions that might be outside of the control of the Vermont State Colleges. It doesn't require notice. It doesn't require a cooling off period. And there are no additional tools for the VSC to counterbalance this extraordinarily powerful action that the union would have available. Our contracts are built with the understanding that SELRA is in place. Both our employees and the VSC have successfully used each of those three critical aspects of the law. And we've used the grievance processes, we've used the contract resolution process, and we've used the unfair labor processes. And the processes work. They're not a perfect solution, but they work, and they have worked to get us to resolution. As recently as 2019, our full-time faculty contract went before the VLRB when we couldn't reach a mutual agreement. Since the VLRB has made its ruling, finding largely in the faculty's favor, the VSC has been successfully able to renegotiate that contract with the unit, sometimes using the assistance of a federal mediator, sometimes being able to do that on our own. We occasionally have grievances that do make their way to the VLRB. Sometimes the findings are for labor, sometimes the findings are for management. And the past decisions that we have with the VLRB provide guidance and precedents for all of the parties that we find valuable. And it incentivizes our parties to come to resolution before we make our way to the VLRB, because we can look at that case law and we can address what those things are. And our unions have filed unfair labor practices, most of which were resolved by the parties without the need for the labor board to intervene. But if warranted, they would have intervened. And the VSC itself could also file an unfair labor practice against the bargaining unit were that to be the case. We really truly understand that our labor colleagues believe that since the Teachers Act and the Municipal Employees Act do allow the limited ability to be able to strike, that it should be allowed for the employees of the Vermont State Colleges. However, there are some really significant differences between the Vermont State Colleges and our K-12 teacher colleagues and municipalities. First, if we just talk about the school districts, the public can't sue the school district for a strike. They also can't sue a municipality for there being a strike related to that. A 2-week strike at a public school is devastating to those families. We all know that. We know that the care of those children, maybe those parents have to take time off of work. They're going to have to find some other alternative to do that. And after the strike has concluded, the school year will be extended and the children will attend further into the summer. And except in very rare circumstances, the families affected wouldn't be able to sue the school district. Further, the school district will continue to receive their dollars from the Ed Fund, and they will continue to receive the dollars from the municipality for the local school taxes. The same can't be said for higher education. We have a contract between ourselves and each of our students. When we fail to deliver the education, we risk a breach of that contract. And when a strike interrupts those services, that means harm to the students by not delivering the education that they expect, deserve, and have paid for. And it means harm to the institution because failing to deliver that education puts our accreditation at risk with our federal accreditors. A very real example of this happened in 2020 with the pandemic. When Governor Scott shut down the state in response to the pandemic, our students were sent home. We closed our dorms and we shut down our dining halls and we turned to 100% remote learning. What was initially believed to be a 2-week shutdown, we all remember that, 2 weeks to bend the curve, turned into more than half the semester. As an organization of integrity, we chose to issue a refund to the students for the room and board that they were not able to use for the remainder of that semester. In our opinion, refunding the students was the right thing to do, despite substantial cost, because students are entitled to the services that they paid for. Had we not been able to turn to 100% remote learning, we would have felt it necessary to refund student tuition as well, despite significant costs that we would have had to continue to incur for running our existing organization. Some organizations around the country chose not to do the same. More than 200 lawsuits were filed. Some of them were class actions. And 5 years later, many of those lawsuits are still in process. Confirming that our decision, the one that we made to issue that refund, was the responsible and defensible position. And while we're fortunate that higher education emergency relief funds from the federal government and the state's input of funds from COVID dollars covered the lost room and board, in the case of a strike, the VSC would not be so lucky. A strike at a VSC institution would create the very, very real possibility of financial ruin. A strike that leads to lost services, such as days, would lead to a breach of contract between our institutions and our students. As a result, as painful as it would be to the institution, we would find ourselves needing to refund our students, despite having all of the continuing costs that go along with it. And to put that into context, the finances of the VSC, each institution are interlocking. Faculty teach our students, staff provide services like advising, support to faculty, financial aid, registration, maintenance, custodial services. And a strike within any of these areas has a direct impact on the operations of the others. Honestly, faculty cannot teach without the support of our staff, and staff can't perform their work if there are no students because faculty are on strike. And yet, if the services are not delivered, we would need to provide refunds to our students, refunds that we would not be able to afford. Yes, a strike would be an extraordinarily powerful weapon for the union to hold. So powerful, it could certainly undo all of the work that has been done over these last few years in concert with the legislature to transform our system into a financially sustainable organization for now and well into the future. Since 2021, we have worked tirelessly to stabilize the Vermont State Colleges, and with your support, we are making progress. I reported to you earlier this session that for the first time in several years, I am able to see the edge of the woods. We're not at the edge of the woods yet, but I can see it, and that's incredibly exciting. Allowing our employees to be able to strike would jeopardize our future that we have so carefully nurtured these past few years. A strike would result in lost education for students, necessitating refunds. We'd still be responsible for our utility bills, for wages and benefits for employees not involved in the strike. Without the tuition from our students, we'd not be able to make these payments. And we'd run the very real risk of what we in higher education called financial exigency, and in the private world, they call bankruptcy. The Vermont State Colleges has very strong working relationships with its unions. Yes, we have disagreements. Management must advocate for what it believes the organization needs, and labor must advocate for its employees. But together, we have to find solutions that are workable for all of us. We believe that CELRA helps us do that. At every turn, it forces us back together for real and honest discussion. It forces us for a look away to find yes, and it forces us to reach out to the other side to find a way forward. There are times when we can't alone do that, and that's where the impasse process and neutral fact finding and ultimately the VLRB come in. When we can't get to yes on our own, we have means that help us get there. There's the continued support of the VLRB, and whose caseload has increased the last few years with the recent addition of several new units. And Vermont's public sector employees and employers are best served by that strong and well-functioning VLRB. So I began telling you about my conversation that I had with Heather Reamer from AFT. And I spoke with her truly because I wanted to understand the reason for the requested change. I spoke with her because I really wanted to understand what was causing us to have this conversation. And honestly, trying to understand, is there an underlying issue between the Vermont State Colleges, where we have 6 bargaining units that are associated with AFT Vermont, and that's a concern for us. And honestly, we do believe that CELRA is the best way to have an honest dialogue between us and come to a solid solution. Not to be adversaries working against one another, but to be advocates for our employees and our organizations who are seeking what is best for the state of Vermont.
Got a question here.
Well, I don't want to interrupt, but are we? Time for
I am
questions?
ready for questions.
First, I want to say, I don't really like the word weapon used as a strike for striking. So I just wanted to say that language I think is a little problematic. Okay, so it sounds like your biggest concern is about people suing for money. Can you talk about how much money that would be?
So tuition, if I just look at COVID and what we refunded for student room and board for half a semester, that was approximately $5.8 million. If we were looking at tuition in that same period, we would have been looking at closer to $18 million. So when we look at what that looks like, it's an enormous sum of money. And so it depends on how long a strike would potentially last. But while the finances and the potential to being sued, and we would avoid that by issuing a refund, while that is a concern, it's also a concern that there are no other protections that are proposed here. It is simply the elimination of one line related to the ability to be able to strike, with no other language in the existing CELRA law that addresses the conditions under which you could strike, what process would be used to be able to follow that. For example, would it be allowed for an unfair labor practice? There's a process in CELRA that allows you to be able to address unfair labor practice. So it's multifaceted. Certainly finances, I'm the chief financial officer, so that would be one thing that I would bring up, but it's multifaceted.
What are the other facets besides finances?
The ability to be able to strike over issues other than final contract terms, to be able to strike under an unfair labor practice, an action that might be taken related to a grievance. Those are all not contemplated in the way that this bill is currently framed.
Is there room for changes in your opinion, or is it just?
I think it would require a significant amount of study to understand all of the interlocking parts of CELRA to be able to do that. It's not just as simple as removing this one line. There are multiple interlocking parts that would have to be studied and evaluated. And I'm not an expert when it comes to that, but I think it would require very, very, very careful study.
Other questions? Do I take it? You said you talked to AFT asking why they're doing this?
I did. I spoke with Heather Reamer last week.
Do you have any conclusions?
I think that you would have to ask them. I was grateful to be reassured that it was not related to actions that are occurring at the Vermont State Colleges, from the conversation that I had, but I don't have any other information.
Do you, what sort of following up on the questions you were just asked, what percentage of the total income that you get comes from tuition?
More than 50%.
I have heard in my role on the board repeatedly that the Vermont State Colleges will only survive fiscally if they are successful in growing admission. And in fact, that did for the first time apparently happen last year. And otherwise, it's just not viable in the future. Is that your opinion?
That is an incredibly fair assessment. Since 2019, so just before the pandemic, the Vermont State Colleges, Vermont State University specifically, has lost 21% in its headcount. In order to be able to continue to be viable, it needs to continue to grow. It saw an uptick in enrollment for the first time this past fall. We're looking at a double-digit increase in student new starts for this fall coming up, so fall 2025. And that growth needs to continue in order for the system to remain viable.
Would, I mean, I guess it's pretty obvious to some extent a strike would affect that, but could you provide any detail as to what a strike would do to that effort?
Any action that negatively affects the brand of the organization in higher education has a detrimental effect to enrollment. So we know that one of the factors that affected enrollment for the Vermont State University campuses, specifically those at Johnson, Linden, and Randolph, was directly related to an announcement regarding closures that occurred in the spring of 2020. Continuing on with that, making an announcement to create a new organization called Vermont State University, which is the merger of several of our campuses into a single institution, also had a knock-on effect in terms of recruitment, because you have to rebuild the brand as it comes to that. The actions of a strike, which would be very public, certainly, would have an impact on enrollment. To what extent, we don't know. We know that K through 12 schools obviously have the ability to be able to strike. In the 1970s, I was a student in Burlington when the teachers went on strike. There was no other option for where you went to school afterwards. If you were a public school student in Burlington, you went to public school in Burlington after the strike. You went there before and you went there after. With higher education, that's not true. Students have the ability to be able to make different choices.
Yes.
Have you encountered any impact with staff attrition or recruitment for teachers to come on board?
For recruiting faculty specifically, certainly in areas where they are in high demand, engineering, computer science, and nursing, we struggle because of the rate of compensation that we're able to pay. But in the vast majority of areas, we have no problem finding faculty who are interested in coming to work with us.
Okay, so you do have a bit in certain sectors.
Yes, but those would be the same
Due
sectors
to
that are.
salaries.
It's salaries and it's contractual with the way our contracts are set up.
Anything else?
Not at the moment.
Other questions?
No, I thought I saw from their side.
Yeah.
Yeah.
Yes, go ahead.
This is not a financial question, but I'm curious if there's something in place for the impact on the students when there's a strike, when they fall behind with their classwork.
So we have a 15-week semester for our students. They start at the beginning of the term, they conclude at the end of the term. In our existing processes, there's no means to be able to extend that because we have terms that begin immediately following the end of the 15-week term. For if it's spring, it immediately, fall, it immediately flows into spring. There's an academic break. Then it flows from spring into the summer term. So there is really no opportunity, unlike K through 12, where they can extend into the school year. And having been a part of that, a couple of weeks into the school year, into the summer, if that's the case. But we don't really have anything that contemplates that, nor is there any way that it would contemplate were faculty, for example, to go on strike. While we went remote during the pandemic, if the faculty were on strike, those would not be available to the students during that strike period. So I'm not sure how we would be able to compensate for that.
Any other questions? Yes.
So I'm just curious whether there's a possibility of some kind of middle ground with enabling faculty to use some kind of tool, but with bumpers. Do you have any ideas of what that could look like?
I'm not an expert in all of the intricacies of the State Employees Labor Act. There may be mechanisms to be able to do that, but I think it would require careful disentangling. And then in many instances, the renegotiation of large portions of the 7 contracts that we have. Our contracts are not just faculty. And as proposed, this would be all of the employees of the Vermont State Colleges and the University of Vermont. So faculty are a component, but the larger component of our employees are actually staff. Individuals who are maintenance workers, custodians, administrative assistants, people who work in the financial aid office and registration. So we have full-time faculty, we have part-time faculty, and then we have several other units.
Can I just follow up about that? I'm just curious how many, what the proportion of full-time faculty versus adjunct or visiting?
So at this moment, I believe we have for Vermont State University, 186 full-time faculty, and we have a little more than 200 part-time instructors. Part-time instructors can teach only a limited number of credits per semester. Full-time faculty obviously teach a full-time load and have other responsibilities. That number has varied from year to year. In some years, a part-time instructor may only teach 1 course. The next semester, that same instructor may teach 3. So the number of part-time instructors is highly variable.
Can you repeat those 2 numbers, please?
We have 186 full-time faculty and a little bit more than 200 part-time instructors at Vermont State University. Thank you.
I think that's important to bring up also that when we think about this, that we're thinking about staff of colleges often who are making lower wages, adjunct faculty is staff. So it's important as we discuss this to think about all the staff members that are at the colleges too.
Any further questions? Sharon, thank you so much.
Thank you.
Our next witness is Matt McGrath, who's organizing director of AFT. Is Matt here?
He is.
Please come up and sit down.
Grab a tissue.
Here.
Matt?
Good morning.
Welcome to the committee.
Thank you.
I'll tell you what, we didn't do this for Sharon, so Sharon can watch. Members of the committee, would you introduce yourself?
Gladly. Good morning. Ashley Bartley. I serve Fairfax in Georgia.
Leonard Dodge, Essex.
I'm Charlton, Athens, Chester, Grafton, and Linden.
Debbie Dolgan, I represent St. Johnsbury, Concord, and Kirby.
Gail Pezzo, Chittenden 20, Colchester.
I'm Mary Howard and I represent Rutland City District 6.
Good morning. I am Representative Elizabeth Burrows of West Windsor.
Hi, Emily Krasno, Chittenden 9, South Burlington.
And I'm Mark Mahaly, Callis, Plainfield, Marshfield, and welcome.
Thank you.
Just tell us your name for the record and take it away.
Sure. Yes, my name is Matt McGrath. I'm organizing director at AFT Vermont. I've been on staff at AFT Vermont for about 12 years. I'm Heather Reamer's colleague and, can speak to AFT's position on this legislation. I think where I'll start is just to say we agree, it sounds like with both the state colleges and as Sophie reported on the National Labor Relations Act, that this is a strike is a tool to help the parties reach agreement. This is really about reaching an agreement. And I guess I'll start by just sharing a little bit about why the current law isn't actually sufficient. Well, and just one note, I think, just to address one of the points that Sharon made is that all 6 of the contracts that workers have at the state colleges actually have what we call no strike clauses in them. So there are plenty of tools that the parties can agree to together to extend anything that doesn't get addressed by law. So under the National Labor Relations Act, there isn't a whole ton of guardrails in the law. But so what happens is the parties then come together and have discussions at the table and reach agreement. So every one of our contracts in the private sector where the folks do have the right to strike, the parties have reached agreement on what we call no strike clause, which says during the life of the contract, the union isn't going to strike, management isn't going to lock the workers out. So it's not to say that and that exists actually currently in the state colleges, even though they don't have the right to strike, there is an agreement. So actually under current contract, workers at the state colleges have agreed to not strike during the length of a contract period. Does that make sense? So on any issue, on like you were talking about, if it's a grievance, if it's a wages, if they don't like DEI, they've already agreed that they cannot strike during the length of any contract period. And if they did, that would be an unfair labor practice charge that the employer could bring on the workers.
I'm just gonna ask the question.
Sure.
And I apologize because I understand I came in late. I actually have several constituents who are very concerned about this bill. And my understanding is right now, so they both work for UVM. Right now, they are not under contract and haven't been under contract since July. Do you know?
Sure, yeah. So, and I might defer to the next testimony is Ellen Casey, the president of UVM Staff United, and I believe probably talking about members of her union. Yeah.
I will cover all.
So anyway, just, again, just to acknowledge that the International Labor Organization, which is an agency of the United Nations, has also determined, the right to strike as a fundamental right of workers. And I just want to share a little bit about why, and it's because, when folks don't have a union, they have no say in the decisions about their workplace, right? And this isn't to say that all employers are bad, right? There's plenty of employers out there, especially smaller employers, who do a great job of engaging their staff in, how the business runs. And includes folks in those decisions. But at the end of the day, management has the right to make those decisions. So folks organize a union so that they have the legal right to bargain over their wages, their benefits, and their working conditions. So in theory, right, like the reason why organizations like the United Nations will say this is a fundamental right is because it just allows them some democracy in the workplace. And in theory, it's like a 50-50 say. You come to the table, you bargain, you reach agreement. And, I think what everybody seems to be acknowledging is that for that process to work, there has to be equal incentive on both sides. There has to be equal leverage on both sides in order for the parties to feel compelled to reach agreement. If one party has more incentive, to prolong the process or to drag things out or to not reach agreement, they may use that to their advantage. And I'm not saying that that's necessarily what any of the employers we're talking about do, but they have that advantage. And so, it's our position that, by giving the parties the right to strike and the right to impose or the right, to lock out, it basically, it gives folks the same amount of leverage. And it gives folks incentive to come to the table and reach agreement. And at the end of the day, that's what this is all about. I shared a slide. I don't know if that was prepared and if I shared it in advance, but is that possible to put up there? Okay. I mean, basically, I just was comparing. And so if what, I didn't mention this before, but so at AFP Vermont, if you weren't sure, actually over the last 7 years, this organization has grown 3 times. And so our membership now is about 12,000 folks here in Vermont in both healthcare and in higher education. So both at the state colleges and the university, the staff and faculty, and also nurses, support staff, techs at a number of hospitals and other facilities. And so all of the hospital and healthcare staff are in the private sector. So those folks, as Sophie identified earlier, are governed by the National Labor Relations Act. So it's federal legislation. And the higher ed folks who we're talking about here today are in our public sector. So that's state law. So I just wanted to point out, so in the private sector, because I think one of the things to me that is indicative of the differences here is in the private sector where folks have the right to strike and where it says contract reopeners here, the green box, these are unions they've been around for a while. So these are not their first contract. So generally the first contract might take longer because you're negotiating the entire thing. And the reopeners, you're generally just opening portions of the contract that the parties want to adjust, right? And so you'll see that, so at Porter, so we represent the nurses at Porter and Middlebury, and UVM nurses and techs, they have separate bargaining units, they bargain separately. Community Health United is the community health centers of Burlington. PPNNE, that's the statewide Planned Parenthood folks. This was the length that it took them to bargain their most recent contract. So you'll say 3 months, 3.5, et cetera. So it was an average of 3.7 months. It took each of these private sector reopeners from the day they sat at the bargaining table to the day that the union ratified a contract agreement. So, and then in the blue box, you'll see these are first contracts. So these are where folks were going from nothing to a first contract, which generally speaking is understood to take somewhat longer. But in these cases, the support staff and the techs at Porter Medical Center, the support staff at UVM Medical Center, and then the nurses and the techs at CVH or Central Vermont Medical Center, that's how long it took there, for an average of 4.6 months from when they sat down at the bargaining table to when they ratified an agreement. And here's the public sector, and these are all not first contracts. These are all reopeners. It took, as you can see, an average of 8.5 months. And Ellen will speak to this more. UVM Staff United are currently still in bargaining 13 months after they sat down at the bargaining table. Obviously there's lots of factors, right? I'm not saying that not having the right to strike isn't the only factor, but it's hard to look at this data from my point of view and see how there's something different here. And the main difference here is that these folks don't have the right to strike. And so, and management doesn't have the right to impose. And so there's nothing forcing the parties to really reach an agreement. I think just to say a little bit about the current system and why it's not functioning so well is, I think, as Sharon was indicating, the VLRB, is the mechanism that we have to file unfair labor practice charges if the employer engages in illegal behavior, or you can take, after going through the process of mediation, fact finding, and you still don't have resolution, you can't reach an agreement. And that process is very onerous and time consuming and costly. Then you can, submit your last best final to the VLRB, but they are so overworked right now and underfunded. It literally is taking 2 years to get resolution on unfair labor practice charges now. So, we have to consider, is it even worth filing a charge? Like, do we want to get resolution for some grievance 2 years from now? Maybe they won't even be living in Vermont anymore. I mean, seriously, we really can't consider the current labor board, and I'm sorry to say this, like a useful tool to enforce labor law. And so I think workers are, understanding that they have to take, matters into their own hands. And again, I think the final little box here on the slide, just to point out, like every one of these contracts was settled without a strike. Going on strike is never the goal. Healthcare workers, teachers, folks who work with students and like really care deeply about these folks, they don't want to go on strike. Like making that decision is incredibly difficult. And it generally doesn't happen. You know, I'm more familiar with the healthcare side of things, but there's been 2 strikes in the history of healthcare organizations in Vermont. And only one of them was about a contract dispute. The other one was when the Copley nurses organized, it was just a strike to recognize their union. But there's been one strike in all of Vermont in healthcare. And there's not that many in general at all. So I think you're going to hear a lot from the opposition talking about what's going to happen in the case of a strike. And I would suggest, right, we don't generally write policy for the thing that could maybe happen, but probably won't. We should write policy based on, you know, what is the thing that does happen all the time. These parties come to the table all the time to negotiate. So let's give them the tools to be able to come to agreement quickly. Because the other thing that I'll say, like the concern that I have in terms of resources is when bargaining is dragged out, right? When we have 6, 7, 8, 10, 13 months of bargaining, what we have is a bunch of people who are on both sides of the table who are focusing a lot of their energy on bargaining a contract, not doing the principal function of their job. So we're losing resources from really competent people who are not actually working for the institution that they're supposed to be working for a big chunk of their time. You know, in addition, you know, the employers generally hire outside counsel to support bargaining. That's in addition to their, you know, to their in-house counsel that charges hundreds of dollars an hour. So, and we know from information requests at UVM anyway, they've hired the same law firm that Starbucks has used to sort of, you know, to bust the unions at Starbucks, charges $500 an hour. And from when bargaining started through November, they already spent $50,000 on that lawyer. And that was before fact finding even started. So we're confident that because of all the work involved in fact finding, that number is probably significantly higher. I mean, definitely significantly higher, but we just haven't gotten that information yet. So I couldn't tell you exactly how much it is. So in terms of resources being spent, our concern is that if we continue to allow contract bargaining to be dragged out longer and longer, that's actually a more significant drain on resources than what if the chance workers decide to strike in the future, and what are the ramifications of that? I'll also note, I think, you know, when Sharon was talking about all of the lawsuits that came about post-COVID, maybe you can follow up. I mean, but the language that I heard her say was that they're in process. Our understanding is that there has never been any successful suits in these cases, where when folks have brought suits suing, and we know this because actually there's a number of teachers unions who have gone on illegal strikes, right, in other states. And so some of these right-wing organizations that try to find a student to be a plaintiff will also sue the union for damages. And in none of these cases, they have actually been successful. So, you know, of course, there's been settlements because some organizations want to do the right thing and make sure students are made whole, but that's their choice. There's never been any successful suits. So, you know, we think this is a little bit, it's not rooted in any serious fears. Sure, it's possible, but there hasn't been any success. And so I think, I hope that as you're considering this, you're thinking about, like, how do we help these parties reach agreement in a timely manner? That's really what this is about. And on the sort of the guardrails question, I think, our position, our strong preference, because fact finding is expensive and onerous and takes a long time, is that we actually, move forward with the right to strike without the parties being mandated to go through that process. But if it is a situation where you all feel like there needs to be some guardrails and, in order to move this thing forward, we would be fine with adopting the K through 12 language, as a model for adopting with the SELRA, for the higher ed folks.
Thank you. Questions of the committee?
No, I just wanted to add something. I appreciate what you're saying. And I just want to remind folks that when people are speaking out, it's because they're organizing for better working conditions, better wages. This isn't something radical. And when there's a reason to organize, it's because of those injustices for staff and people. So it's just important to note that those are the reasons. And I value those rights that people have. And I think that they should have that right. And so I really appreciate your testimony.
Questions? I have a couple. Oh, go ahead.
I was just curious whether, because I have gotten a lot of, emails from constituents and friends. Guess I'm pretty nerdy. I have a lot of faculty friends. And this means a lot to them. And, you know, to become faculty these days is harder and harder, and to stay faculty these days has become harder and harder. And so I think that unless we come up with something other than a right to strike, there's got to be a way to shorten these ridiculously long contract negotiations. And I haven't heard other options, other proposals on the table.
A couple of questions for you. One is, on the chart you showed with the delays, you showed the delays and there was like a lot longer delay for the public than the private, where there was a right to strike. And then you talked about this huge backup at the Vermont Labor Relations Board and their inability that things took so long. Did any of those public sector contracts go to arbitration? Or did any of them go to the Labor Relations?
No,
Did any of them go to arbitration?
no, but the process that we have available to us under CELRA is, so, the parties meet, the one party declares impasse, then you have the opportunity, and just as another aside, that's when the parties can agree to have a mediator. And just yesterday, so we use the FMCS, the Federal Mediation and what's the word? Conciliation, thanks, I'm not a lawyer, services. Thanks to DOJ, I suppose, just fired all of their staff.
Yeah.
So we have federal mediators who are working with us right now who called us yesterday and said, we can't be there anymore because we've been fired. And that's free. It's a free service. So, it's a no-brainer for the parties to say, yeah, let's get the FMCS in here because it's a third party. Let's see if they can help us get closer. It doesn't cost us anything. So now I'm sure soon enough, if this cuts, maintains, we'll probably be coming back here to talk about some state funding for mediation. But anyway, so then you have mediation, and then if the parties are still not coming to agreement, it's a fact-finding process that Sophie talked about. That's non-binding, but in and of itself takes at least 3 months, just because of how, and maybe more. At UVM, and Ellen can talk about this most recently, it took almost a month just for the parties to agree on a person. And then so that it took even longer. And so that's where after 13 months, that's where it's at. We just got the fact-finding report, and parties are meeting tomorrow. So, but after that, it'll go before the labor board if they don't reach agreement at that point.
You said earlier that, well, I just want to give you a chance to respond. Sharon testimony indicated that implied that equality would either mean the status quo with no right to strike, or the right to strike on one side and imposition of contract on the other, which is what I guess the teachers have.
Right.
And when you say you're open to using the teachers as a model,
right,
that would include the imposition of contract.
Right. Yes.
And do you prefer strike plus contract imposition to the status quo?
Yes. Yes.
Okay. Any other questions?
Wait, can you tease out imposition of contract? I didn't quite.
Imposition of contract is under the teachers and I guess one other of the contracts where there's a right to strike.
Right.
The employer, I guess after a certain point, the employer can impose a 1-year contract. They can say, okay, here are the terms, and impose a contract for a year. After the expiration of the year, if the parties still then can recommence their negotiations for a new contract. and the process starts all over again. So it's giving both sides extremely powerful weapons, the right to strike on one side. Sorry,
So
I guess both are weapons in a way. Extremely extremely powerful tools. Yeah. Okay.
And they happen like the law allows those things to happen at the same moments in the process. So like both parties can either strike or impose at the same moment in time, right? So you're coming to that point and you want to avoid that. Neither party wants to do the thing or they don't want the other party to do the thing. So the goal is you get a deal done and
Yeah.
Are the contracts usually a year long or are they longer?
I think.
longer usually. They're usually 3 or 4 years is pretty common in these contracts that we have here. And I think I'll just say, you might have heard, for example, this past summer, the nurses at UVM, they did not go on strike, but they authorized a strike. So this is all part of the process, right? If they have the right, they're, indicating to the employer, look, we've talked to all of our members and our members have taken a vote and our members have decided if we don't get to X, Y, and Z place, they have authorized the bargaining team to call for a strike. And so there's I don't want to say a million, but there's many steps before workers actually walk off the job. In each of those steps is designed to make it clear to the other party and the community, like, this is where we're at and this is what's going to happen if if we can't meet in the middle. And the employer does the same thing. They indicate that they are going to impose, or on the private sector, it's generally lockout. So they can lock workers out, right? They could hire scabs or they could hire travel nurses or what have you and say, well, you're not. So that's their threat. And again, so I'm just saying, you probably heard about it in the news. They didn't actually go on strike, but they were just talking about it. And guess what? They got a deal and it took 3.5 months and everybody's happy and they're back to work for 3 years.
Because there was a panic.
Well, it was pressure. There was pressure on both sides. And now they have a 3-year contract. So, and in that contract that they agreed to, they have a no strike clause and a no lockout clause. So for the length of that 3-year contract, the nurses cannot strike and the employer cannot lock them out.
Right.
Go ahead.
I'm just curious if you can tell me what the condition is without a contract. Like for these 10 months or 8.5 months, is it just you're under the old contract or you have no contract?
Yeah.
What is that no or
Sure.
when you can't reach a contract look like for people?
Right.
And
And
for the institutions maybe.
And again, my expertise is more on the healthcare side of things, but so I think generally the case law, at least on the private sector side of things, suggests that the contract by and large is in effect still. There's certain things that don't apply. You can't take grievances to arbitration, for example. The no strike, no lockout clause does not apply. Right. Well, and then, generally the contract, you've negotiated, say, a 3-year contract, you have specific raises for each year. So you're going without raises. So there's no, unless you bargain, I think there are some contracts here on state contracts where they have an automatic COLA that happens every year regardless. So unless you bargain that in, you wouldn't be getting any additional raises.
I would like to ask, but I don't know that you're the right person, somebody, whether it's one of the witnesses, how long it's taken to negotiate contracts with the Vermont State College.
Well, I had that on the sheet. I handed out to you there. Those are in the bottom box there.
VSC full-time faculty, is that what FF? stands?
Yeah, that's the full-time faculty. This is the
Okay, got it.
professional staff
Okay,
and the non-professional staff. These are legal terms. I don't prefer them, but then that would be the VSEA unit. So that's why it's not on here because I'm not sure.
yeah, see, full-time faculty and UP.
And then CCV, this was 6 months. So that's also state colleges.
These 3.
Okay. Any other questions? Matt, thank you so
Thank you
much.
so
Yeah, my pleasure. Thanks for having us.
The next witness is Ellen Kay. Are you Ellen?
I am. Good morning.
Ellen, you, hopefully saw the introductions of the members of the committee.
Yes, I was paying close attention. Thank you. So my name is Ellen Tay. I work full-time at Howell Library at University of Vermont. I've been there over 6 years now. And I serve as the co-president of UVM Staff United, which represents 1,500 clerical, technical, specialized, and professional staff at UVM. We have sister unions all over, sibling unions all over UVM. There are five unions. 2 of them are AFC, faculty and staff. There's a graduate student union fighting for its contract. There is the United Electrical, which represents custodial and maintenance staff. Who am I forgetting? The police, yes, the police, which is now the New England Police Benevolent Association they're affiliated with. And there is also an interesting 6th union, which is the Sodexo workers, which do not work for UVM. They work for the private sector. So that's that's the landscape at UVM. As I said, I am full-time at UVM. I'm not paid. I get no salary to be a president. I do all of my work and do this. I'm taking PTO today. And all of our union is that. We do the work of our union. That is the kind of union that we have. We formed this union in the spring of 2021. We won our first contract in spring of 2022. We are now, as you've heard, bargaining for our successor contract. We began bargaining in February of 2024. That is the fabled 13 months. So it's still unresolved 13 months later. And so I'm here to talk to you about how critical the right to strike is for higher ed workers in Vermont. And our struggle for a contract provides a strong case in point. From February to August 2024, management never moved on their 2.6% wage increase proposal. Staff decreased our proposal to move toward them 4 separate times. The median income of our unit, just to help you understand, we're talking 1,500 people, is $55,000. HUD.
You said median?
Yes. HUD considers a single wage earner in the greater Burlington area who makes less than $66,000 to be low income, meaning not be able to afford housing costs. 70% of our unit is paid a low income wage by those standards. We have colleagues who have dedicated 30, 40, and even 50 years to UVM, who, as we talked earlier, care deeply about the work. Why would they be working for this kind of money? They didn't. They still make under $55,000. I have a 39-year colleague, been there 39 years, makes about $45,000. It is not unusual for my coworkers to work second jobs to make ends meet after working full-time at UVM all week. We made good gains in our first contract, which were eroded by sharp pandemic cost of living increases, as well as soaring health insurance premium increases. The wage increases we have proposed for the second contract would move us toward a livable wage. We're not asking UVM to go all the way. We just want to move in the right direction. After settling around 50 contract articles from February through August, we arrived at impasse. We declared impasse over wages, over lack of movement and wages, and began the fact-finding process, leading to a fact-finding hearing in November, 10 months into negotiations. Now, UVM staff, our union, has spent $34,000 in legal fees to prepare for and execute the fact-finding process, and $7,000 we pay for half the fact finder, the neutral fact finder, and countless hours of our bargaining team's time, all volunteer time with little release time for doing this work. Throughout the last 13 months, we employed all methods to persuade UVM to come our way. Great bargaining skills at the table, doesn't do it, isn't sufficient. So that includes petitions, letters, op-ed pieces, rallies, including with Bernie Sanders, who joined us at one of our rallies, work-ins, and testifying at Board of Trustees meetings. UVM, in the meantime, as Matt alluded to, hired a $500 an hour attorney from a national firm, Littler Mendelson, which also represents Starbucks and Amazon against their workers, to sit in the bargaining room for several months during the proceedings. We noticed somebody sitting there, didn't know he was, and then to take over negotiating with myself and my co-president, who we serve as lead negotiators. We do not have a lawyer at the table. Fact-finding is the only time our union has used attorneys in dealing with UVM management because we are a worker-powered union, excuse me. UVM threatened somewhere around May that if we didn't accept their below inflation proposals before our contract expired on June 30th, they wouldn't make our increases retroactive. I understand what that means, I hope. So we have been working since July 1st with no increases, and therefore no increases to our retirement funds as well. In fact finding, we learned that though UVM never offered us more than 2.6% increases, it had in fact budgeted 3% raises for our unit for fiscal year 2025, which began on July 1st. We were never offered that at the table. Last week, the neutral fact finder issued his recommendations, which include raises of 4%, 3.75%, and 3.5% for the 3 fiscal years, and has unequivocally stated that they be fully retroactive, stating a potential recommendation that a contract should not be retroactive would provide a public sector employer with an unfair advantage in bargaining. The public sector employer might deliberate in bargaining, knowing the longer it took to reach an agreement, the more money could be saved because the settlement would not be retroactive. That's one quote from Mark Grossman, the neutral fact finder. And very apropos to the topic of this hearing, he went on to say, on the other hand, a union without the right to strike would have very little leverage to speed up bargaining, other than making concessions it might otherwise not have made.
I guess, let me interrupt. So is it, in terms of your filing an unfair labor practices claim because they're delaying and delaying, is that not possible because the Labor Relations Board is so backed up?
Correct. That would not speed up negotiations in any way at this point. Yeah.
But it would go,
It's not possible. Yeah,
I mean,
well, we think, we think
delay
it's bad faith bargaining.
unfair labor practice?
they're coming to the table. They only have the duty to meet and and pass proposals. There's no obligation to move on their position.
We would call it bad faith bargaining.
Yeah.
But going to the labor board for all the reasons that have been.
Just because it's so long.
Yeah, and yes, and our goal is to have an agreement at the table between the parties.
Another question, what was it? Just to get the time right, I'm not sure I've got it.
Sure.
So there was this period between February and August with very little movement of any sort, and then fact finding was requested when?
Okay, so in August, we did bring in a FCMS mediator, FMCS mediator, who worked with us throughout. I don't remember when we started with her. May, June, July, maybe we'll say June. And so she worked with us going back and forth between the parties, all sorts of creative, attempts at movement. And then in August, we called for impasse. We said, we are ready to keep doing this.
And so that's when the fact finder was brought in.
That's when we agreed to a fact finder. The VLRB has to appoint the fact finder. It took quite a long time to haggle over who the fact finder was going to be, what was acceptable to management. We brought 5 or 6 different candidates. We gave them information about different candidates who could be the fact finder. They kept saying no. So this was just yet another difficult negotiation.
Was
So
the
then
fact finder appointed then?
October, I want to say, do we know? I don't remember, somewhere in the fall. And it took until November 18th to have a hearing. Having a fact-finding hearing is an onerous process. We assembled a binder that's about this thick. All of our members working on the pieces of data and the case. It was an incredible process, but all done in our spare time, weekends, evenings, all of that. with the help of lawyers who consulted with us, who helped build our case. But so we had to do that to be ready for the fact-finding hearing. We went to the hearing, and it was a very formal proceeding. And then and following where we're on the stand, and then they're on the stand, and people are under oath, and it's recorded and all of that with a court reporter who we also had to pay for. That's November 18th. We had to file post-hearing briefs, each side. That took until the beginning of January. Then the fact finder estimated that his report after that would be 30 to 60 more days.
And it just came out when?
It just came out on the 18th, 19th, about the 20th, 21st. Am I right about this?
March.
It's like, yeah, it was just like about a week ago. And we've been, you can imagine now, our union is just working incredibly hard, preparing for a bargaining session that we invited management to on Friday, which is tomorrow. And just to give you a visual of how hard we work, this is our week of action for next week, to continue to keep the pressure on UVM to settle with us. This is everything short of striking, which we cannot do, the reason we're here today. We have had to be very creative. We do work-ins because we can't walk out. We go and sit and work in public places so people see the value of our work and why it's important for us to be paid well. And if I can continue, if there are no more questions about that part, I'd love to just continue, because I'm going to talk a little bit about that as well. We do believe that the fact that we are prohibited from the right to strike was part of what enabled UVM to prolong bargaining, to bargain in bad faith, to threaten no retroactivity as a way to get us to settle for wage increases. And I would call that a weapon, actually. That I think might be a useful word there. To get us to settle for wage increases that actually put us behind the cost of living, rather than helping us move closer to the cost of living after having lagged behind for years and decades. Possibility of a strike, as Max said, is essential to creating a level playing field for unionized workers. Without it, employers hold all the levers of control, and workers have little leverage. Parties need to have equal leverage to come to a timely and prompt agreement. Without it, there is little incentive for the other side to settle contracts. When management prolongs the process, withholding raises and stalling a new contract, it leads to low morale, valuable staff leaving UVM, and a retention and recruitment crisis. And that hurts Vermont, with workers and their families potentially relocating to other states for wages that better keep up with costs of living, not attracting new people, new families, new workers to Vermont because they can't afford the housing at these wages, and potentially making our flagship university unattractive to new workers, and most worrisome, making it less attractive to potential students. Long drawn out negotiations at Vermont's public higher education institutions are a waste of taxpayer money spent on high-priced lawyers and lost staff time and lost administration time, rather than doing the work we care about, the constructive work that make our institutions great places to work and study. And not having the right to strike erodes the democracy our workers chose by forming a union, by not giving us a real seat at the table and a voice in our working conditions and wages. And while strikes are rare and unlikely and not the first tool in our toolbox, the ability to strike levels the playing field for negotiations. Our goal is not to strike. It is to come to agreement. When one side can slow down the process and drag it out, we are not equals in negotiations. Negotiations are about averting a strike. I can't say it more strongly. Thank you.
Question with Ellen. Go ahead.
As I said earlier, I have constituents who are really concerned, who work at UVM. And so thank you, and you answered most of my questions. I'm wondering about retention, like you mentioned. Have you seen a large turnover in staffing?
Yes, believe the figure we used at fact finding was 14% turnover. We all
In the last
experience.
13 months. or-
Yeah, we all experience anecdotally in our workplaces that we are picking up the work of positions we can't fill, of many, many, many failed searches. We're on search number 3 for a position in my library. At this point, yeah.
I just want to offer, so my personal experience, my mother spent, rest in peace, spent decades working at the university for not a livable wage. And so I experienced that firsthand. And I want to just appreciate the work that you are all doing out of care. She stayed there because she loved her job. She loved her students. But it's very hard. And so when people are asking for better working conditions and a livable wage, it's not something that is radical. It's something that should be given to every employee.
Yeah, we believe it's in the best interest of the university's success as
Absolutely.
well. If you balance, how long can you balance your budget on the backs of workers and still have us be able to provide the amazing services that we offer?
I'm sorry, did you have more questions?
I think Joe had a question.
You can go, you go.
As I understand it, the last part of the current process involves either an arbitrator or the VLRB picking a last best offer.
In the process that we're in,
Yes, is that right?
not exactly. We were in the fact finding stage. The
Yeah.
fact finder has issued a report and recommendations. We now have a 20-day cooling off period before we could go to the VLRB to try to negotiate this,
Right.
which is what we're absolutely all pulling out all the stops to do tomorrow. If we understand that if negotiations go on well and they go on a little bit long, we can negotiate 30 more days.
Right.
At the end of whatever period that is, if we have not come to an agreement, the next step is to go to the VLRB with last best and final offers from both sides sealed.
Or do both sides have to agree if you pick an arbitrator?
It's just a VLRB.
It's just the
Yeah,
VLRB.
in this process, it's just
And
the
it's the
VLRB.
VLRB, does that land you back in a long delay because of VLRB?
Potentially. Yeah, we don't know. There's not a lot of experience on that one. We don't, yeah, it could. We don't expect it to move quickly.
So you would make an offer, the management would make an offer, and it would go to the VLRB. And they have hearings or they just decide?
They might take testimony, actually. I'm sure, I'm not an expert on this and we haven't been through it before. But they will impose a decision.
One way or the other.
One way or the other. If they're too far apart, we're told that they will consult the fact finders here, the fact finders' recommendations and possibly go with those.
Sophie, I might ask you, does the VLRB, to your knowledge, Sophie Zadatny is legislative counsel who specializes in labor law, who spoke to us, I don't know if you were here for half an hour in the
Yes.
beginning. Sophie, under the current law, not as possibly changed, does the VLRB have do they hold hearings? Or do they just decide?
They typically would hold a hearing, and then they can choose either management or labor's last best offer, but if they feel that neither is appropriate and there's some language in the statute regarding that, then they can choose the fact finders report. But they have to make a finding to choose the fact finders report.
Any other questions? Joe?
Yeah, I had a question, and forgive me, this is outside of my career realm, so, does the members pay dues to your union for the,
Yes.
is there dues?
Oh, sure. Yeah.
I'm just trying to square the circle of, we don't have an attorney, we do all this nights and weekends ourselves for free. I'm
Yes.
just curious,
We do.
shouldn't that kind of be what those dues?
Well, that's a choice that unions make, whether you want to be worker powered and democratic and engaged and having us do the work. And people have a real stake in their union, which is how our union operates. We do pay dues and we have an item on our budget that is legal. We don't use it much because we are able to use people power to work with the administration directly and come to agreements. That's the way we like to do it. But we do have a budget line for that, but we've had to expend a lot of it this year for this.
Okay.
Yeah.
I was just curious.
Yes, union members vote on dues. That's how that works.
Yeah.
When they organize, they vote and they pick a percentage and that's how that works.
Is that, yeah, I'm equally ignorant on labor law. I'm ashamed to admit, but it's true. Is the due, what's the order of magnitude of what the dues are?
1%.
1% of your salary, gross salary, okay.
Correct. That's what we voted. That's a pretty common number. Some vote more.
Other questions? Yes.
I'd like to know how other states have dealt with their publicly, 'cause we're talking about this. This is coming to our committee because it's a publicly funded set of institutions, right?
Well, we do.
We do both,
We do both.
No, but I mean,
but it's not, you're right. it's
what I
not
mean is,
covered.
the
It's not
government
covered.
has a voice in this at all because these are state dollars that are being expended.
No, I actually don't know the extent to which we could pass laws. Given that the national law covers private employers. But there's no prohibition against us passing laws that affect private employers. We can consider the fact that these are public employees.
Okay, well, I guess what I'm wondering is, whether anybody in the room knows what other state, we often ask, what are other states doing? And I don't think I've heard what other states. have done
Sophie
for public-
testified. I'm sorry, Sophie, could I ask you to repeat? You said there are
I
8 or,
missed it if you said it, sorry.
yeah,
Yeah, so there are about a dozen states that allow some of their public sector employees to unionize. And there are only 9 that allow their teachers, and that's K through 12, so I'm talking higher ed, K through 12. And Vermont's the only one in New England that allows teachers to unionize, but generally public sector bargaining is determined state by state.
I thought we were talking about strike.
I'm sorry, yeah.
Right to strike for faculty or.
Yeah, I don't
Publicly
know.
funded.
I mean, I would imagine if you're a private institution, then you're going to be under the National Labor Relations Act. So it's really down to the publics. Again, if there are limits on public sector, the right to strike for public sector employees, that would then include the higher ed folks too, so.
so it's a dozen states that have laws one way or another that
Right, but not
allow.
necessarily for higher ed, when it's for some employees, so it maybe they allow, like in Vermont, we don't allow currently, under the State Employee Labor Relations Act, higher ed, but we do allow teachers, we do allow administrators in the teaching system, and we allow municipal employees, but we don't allow, other judiciary, other state employees that are prohibited from striking. So there are about a dozen states that allow public sector employees to strike, but doesn't necessarily mean all the public sector employees in those particular states. So I don't have a number specifically on how many states allow higher ed employees to strike.
Debbie, did you have a?
Yeah, I just, you don't have to join the union, right?
There is a choice, yeah.
Okay.
Any other questions on this witness? We will be, okay. Did I?
I have a couple. How many members do you have in your union?
In our unit is, we represent 1,500.
1,500. I'm just, thank you for your testimony. I'm just, I don't understand, but I do understand why it is taken so long. And I can't imagine the stress level of both sides plus the employees. I think it's a shame that you've had the turnover you've had. And thank you for the information. I appreciate it.
And it's a good point because it has the effect of wearing us down. Many members are like, oh my God, we're so tired. We're gonna have to do all this now. We're tired. We're trying to keep people's spirits up so that we don't just cave and say, sure, pay us 2.6%, we're done. That's not right. And that is the power that management had to drag this out. So I appreciate your words. Thank you.
Elizabeth?
Thanks. I just have a couple of timing questions just to satisfy my curiosity. So you said that you got your first contract in 2022. How long was that contract?
3 years, but it was retroactive to 2021.
Okay, so that leaves.
Before you had to start negotiating.
So,
24.
so that's my question is, to what degree do you think that you forming the union affected the practice of 2024?
I'm not sure, what can you, I don't know.
I'm just wondering what, so, maybe I didn't have that, so spring of 2021, you formed.
Mhm.
And so,
Retroactive to 2020.
Yeah, we began negotiating a few months after that, and then 2022 retroactive to 2021 when our union forms. That's how it works. Yeah.
okay. Okay. How easy was it for you to get that first contract in 2022?
We had to work real hard. Yeah, it was an all-out effort. We started in about October on ground rules, and we settled in May, about 1 week before UVM graduation. There was a lot of work. We had good support from AFT because we were all new at this. I was at the table for the first time in my life, helping negotiate a contract, and we learned a ton, but it's a lot of work. Yeah.
You have a question?
Curiosity. 1% of the salaries of 1,500 people is considerable. What do you do with that budget? If it's not, I mean, you're not paid, you're all volunteer driven and you're not hiring a lawyer, what does it get used for?
Well, we have an entire budget for outreach to our members, for education and training. We pay also dues to AFT Vermont and National. Yeah, we don't hire, we have one staff person, but we don't hire him. We do give small stipends to people who step up and make commitments, like the officers and all of the stewards who have to help all of the other folks in their units. Trying to think what else is in our budget. We need certain software for communication purposes. We're running an organization.
Okay,
Yeah.
I'm just curious.
Okay.
Yes, question?
Yeah, I guess I'm trying to. Does the decrease in tenured staff have like sort of the why now?
Are you
Like,
talking about faculty?
yeah,
Oh,
do you
okay.
not cover faculty?
No, that's a separate unit, and that is United Academics, which is also an AFT unit on campus, and that's faculty. We are staff,
Okay,
all staff.
Library.
but you have. But this law would affect
Yes. It would
faculty
affect
as well.
public workers at, public sector workers at higher ed institutions.
And are the faculty and the staff in support of
Yes.
the same bill because it would
Yes.
affect you all?
And as also the custodial and maintenance workers are in support of this, and I know that the graduate students are. Yeah.
Yeah. Yeah, no, I guess I'm thinking about the fact that over the course of my sort of like getting a master's and starting on the PhD track and then just looking at the landscape for jobs, you know, I kind of saw a very dark, at like adjunct life and made the calculation that it just is going to be a sad, sad future for my little Latin American historian heart in Vermont.
Yeah.
And I think that, and I was told by a lot of my own mentors and professors, it's really tough going, you know, every college will hire one in their history department. And you may or may not ever get on a tenure track.
And the faculty worked very hard for adjunct and part-time and lecturers. They also had quite a struggle, which they only recently settled. Yeah, no, it's,
So I think I'm just trying to get like into the global picture of like, why has this right to strike not been kind of, why hasn't it bubbled up to the surface before? And, you know, and I think that there has been this sort of tradition of colleges as being sort of places of privileged, protected jobs with deep respect and now it's much harder for that type of reality. And there's a lot more of, you know, side jobs and hustles and having to.
I think what we should do is allow this witness to step down unless people have questions of her. And we can, so thank you very much.
Thank
We
you.
really appreciate your testimony. I think it's safe to say the committee will be taking more testimony on this issue. And so I thank the three witnesses we had today. It's been, as they say, an education.
Yep.
So for members of the committee, at this point, we do not have any other obligations for the day except, but I do want to thank everybody for their work on the housing bill and what happened. And their work, you know, everybody here contributed to that. And I want to thank you for your work on actual presentation. Also, everybody should be rooting for Debbie on the floor
Woo, woo,
today.
came up quick.
Her first appearance is on S-106
Yes,
or H-106.
with H.
H-106.
You're gonna crunch it.
Yeah, you're gonna do great.
We're all.
And I'm reminding everybody that the committee dinner is next Thursday, the 3rd.
Yes.
And I have, in a moment of a fit of, I don't know what, promised free drinks on my tab for everybody if it passed out of the house.
Wow.
You say.
Oh, welcome.
Hey. Hey.
Free drinks for the free. Oh, I heard three. So did I. Yeah, we heard three down here.